All right, I'm going to answer the question. My patents have been infringed. How do I sue for patent infringement? Hi, I'm JD Houvener, owner and founder here at Bold Patents Law Firm, a patent attorney, and also an inventor advocate. I've been helping inventors for almost 10 years now, and I've gotten almost 500 patents issued as of today. I'm also the author of Bold Ideas, The Inventor's Guide to Patents. It's a great book available by download. If you want to click below the free Inventors Kit, that link will take you to get access to the book and a lot of great resources. So let's get started. You think you have an infringer. You found someone who's infringing your patents. Okay, as an inventor, business owner, entrepreneur, it is easy to get emotional and get very excited about someone else ripping you off, copying you, what you believe to be infringing. One of the first things you should do before sending a nasty letter, email, calling, or trying to draft your own infringement suit is to hire counsel. It's sort of an obvious answer, but to check with your patent attorney to see, confirm whether the actual product that you think is infringing is indeed infringing your claims. You have to identify what kind of patent portfolio you have. For your product, you may only have a design patent, which is fairly limited in terms of its scope of protection. And you have to have a very precise, exact match in terms of the shape and the look and feel of your invention for it to be an infringement. If you have a utility patents on your portfolio, you need to then take a real good look at your patent claims. And the claims, the words, that's what you really own. So when you have a numbered set of claims at the very end of your issued patent, your attorney will look at the independent and dependent claims there to see how close that other alleged infringer really is. For each claim, and specifically the independent claim, usually claim 1, is ordered in certain type, right? Depending on the type of claim it is. But if it's a standard device claim, for example, it will have a preamble, the invention, disclosing a solution comprising the pieces of each of the elements. And typically there are more than one element to an invention. So let's say there's 3 elements, right? Element 1 discusses a housing. Element 2 talks about the attachment mechanisms. And element 3 talks about how there's air being circulated inside the housing. All right, fairly simple, okay? And so there's obviously going to be more details to those. But those are the 3 main elements: housing, attachment mechanisms, and air being blown. Well, for that infringer to be liable, they have to have the as described housing, attachment mechanisms, and they have to have air in there. If you don't see any specific attachment mechanisms, it's all one piece, for example, and there's really no way to say, yep, that's the attachment mechanism I described in my invention. They only have elements 1 and 2. They will not be held liable for an infringement, even if it looks very similar. Seems like, right, after further analysis, your attorney may come back with, gosh, they found a way to design around your invention. So those are ways you can look at it. The other approach, let's say you do get that confirmation that your patent attorney thinks, yes, this is an infringement or it's very close and worth enforcing. That's the time where you want to be careful, pump the brakes a little bit, and see if you can find a way to settle or negotiate with your infringer and make money, make business work. The knee-jerk reaction is to send them a letter telling them, we've got damages coming, we're going to sue you, you've got to stop production right away. The other approach could be, actually, hey, we think there's an infringement here. You may not have known about it. We want to make sure you're aware of it. And even if you are interested, we'd like to do business with you and allow you to continue to produce the product. And all you got to do is pay us a royalty back. Let's have a conversation. See how nice that is? That's a lot more resounding and can be more receptive, better received, I should say, by the potential infringer. So let's take a tactical approach. Don't necessarily threaten, flex your muscles, and try to get someone to react. You want to try to work with them as another business owner, another entrepreneur, likely taking the assumption they didn't know about your patent. All right, everybody, have a great day today. I'm glad this was helpful. Again, please download that kit. That's how you're going to get access to my book, as well as the different options you have for patent searching and application drafting. It's been a pleasure talking with you today. I'm JD Houvener with Bold Patents. Go big, go bold.